Hello, I'm Kirk Hansen, Executive Director of the Markkula Center for Applied Ethics at Santa Clara University. We are very privileged today to have with us Chief Justice Myron Steele of the Delaware Supreme Court. Chief Justice Steele has been in office as Chief Justice since 2004 and on the Supreme Court since the year 2000. Prior to that, he served on the Chancery Court, the Corporate Governance Court of Delaware, and even prior to that on a number of other courts at other levels within Delaware. His extensive experience gives him a special standing to talk to us about corporate governance and corporate responsibility. Chief Justice, thank you for being with us. I'd like to explore sort of the foundations of Delaware law around corporate responsibility and the duties of directors and others. Fiduciary responsibility is the core concept. Can you tell us a little bit about why that's the foundation of Delaware law?
Sure. Let me begin with the fact that the Delaware General Corporation Law sets the standard for the structure of internal governance, and it's a flexible structure, admittedly. But Section 141 has within it the core principle that it's the board of directors that has the authority and the responsibility to manage the direction of the corporation, both a supervisory role and an hands-on role. There has to be an accountability system. The accountability system that is developed from the common law, or what we call, at least in southern Delaware, fiduciary duties, and I understand in California it's fiduciary duties, yes. So I'll try to conform to the local lingo. Those fiduciary duties, as they have been explained in the case law, focus on a duty of loyalty and a duty of care, both of which must be carried out in good faith. Those fundamental core principles have been a part of fiduciary duty law and the common law for hundreds of years, but they're sharpened in their utility when you have a dispute between the investors in a corporation and those who are managing that investment on their behalf. Therefore, the directors are fiduciaries to the corporation and in some instances to the shareholders as well.
How does the concept of the responsibility of directors that the Delaware court focuses on compare to any kind of responsibility the court has to shareholders? Isn't there a balance to be struck between shareholders and directors managing the company?
Well, your question has focused on what is creating the most tension in corporate governance today. A very prescient question, because the issue is about an appropriate balance or tension between the authority that's exercised by the board of directors, which has an accountability mechanism, fiduciary duty, and increased influence, if not authority, on the behalf of the shareholder class over the direction of the corporation. Shareholders do have, under Section 109 of our code, and it's comparable to the general corporation law elsewhere, the Model Business Act of the ABA and throughout the country, shareholders have an opportunity to propose bylaws. The extent to which an aggressive shareholder base proposes bylaws that purport to affect the direction of the corporation, when that authority rests with the board of directors, creates a natural tension, because the shareholders have bylaw authority, so does the board. The shareholders can, if by 2/3 vote, amend a charter, but only after the board recommends a change in the charter. Shareholders now, with proxy access on the table, will have an opportunity to present slates of new directors when they're disenchanted with the direction that the directors have taken for the corporation. And now, contrary to 20 years ago, an overwhelming majority of boards are elected annually, which gives shareholders a faster opportunity, for lack of a better word, to remove a board in an annual election if they're dissatisfied with board's performance. But as shareholders exercise their authority, there is no accountability mechanism. Traditionally, the law has imposed no duty on a shareholder to act other than in the shareholder's own best interest, unless they're a controlling / majority shareholder. It's going to be interesting to see, as this fleshes out in the shareholder empowerment movement or the shareholder rights movement, whether the common law develops a framework for accountability for what I like to call, just for the sake of stimulating discussion, a wolf pack mentality on the part of institutional shareholders who may band together to change altogether the strategy by bylaw or otherwise of a board.
Let me ask about the mechanisms for accountability for the directors then. The Delaware courts have used three concepts. One, the concept of good faith, and then what has been described as the duty of loyalty and the duty of care. How do each of those help define the responsibilities of directors?
Okay, arguably the most important one, if you're focused on potential liability on the part of a director who's failed to carry out his or her fiduciary duties, is the duty of loyalty. Duty of loyalty cannot be, a failure to exercise the duty of loyalty properly cannot be exculpated. That means that the duty of loyalty's focus is on, first, whether or not directors are disinterested in the action that they take. They have no personal benefit, or they have the same personal benefit as the shareholder base, so they're not acting in their own interest as opposed to those to whom they owe the duty of loyalty. And then secondly, directors must be independent and exercise judgment objectively. I like to oversimplify the concept of independence by saying, in a particular factual context, can the court be certain that directors are able to act objectively, not influenced by any outside influence? They may get no personal advantage, no financial advantage or future advantage of any kind. It may not result in them being entrenched in their board seat. But they have to be able to make a judgment objectively independent of anyone else's interests. So we're always careful to scrutinize whether or not those two elements of the duty of loyalty are present.
That's a higher standard than just, do you have a financial interest?
Oh, it is. It is. You have to look at the duty of loyalty as having two components. Traditionally, when I say that, I mean 50 years ago. As I get older, traditions get shorter, but 50 years ago, the focus was on whether or not they had an economic interest in the outcome of their vote. It's more than that today. There's a focus more carefully on their ability to be independent in the sense that they are objective in their decision making, not influenced by anything or anything else other than the best interest of the corporation.
And the duty of care and the concept of good faith?
Well, the duty of care, apart from the concept of good faith, the duty of care is an independent duty, and that's a duty to, before you reach a decision, to gather together all of the information reasonably available that would be material to that decision. That's number one. Number two, to assure there's a record that shows you spent time considering that material thoughtfully and carefully, prudently, I should say, rather than carefully, before you cast your vote. If you carry out those two steps, then you will have satisfied your duty of care.
You can make a terrible decision, but as long as you have exercised care.
Well, yeah, you can make bad decisions. The purpose of using the corporation as a vehicle to enhance wealth, both for the investor and for society generally, is there has to be risk-taking. You can't have a board that's so risk-adverse that they don't advance the investment. So the question becomes, after they make a judgment, and you see that judgment is challenged, you look to see whether it's a disinterested, objective decision-making process, and whether or not that process itself gathered together all the information material and sufficient time in the process was spent on those materials so you can be comfortable that the board has exercised the judgment prudently. That's the duty of care. Now, good faith comes into the equation, and importantly so, because both those duties have to be carried out in good faith. And we generally try to characterize that as a conscious disregard of either the exercise of interest-free, independent judgment or a conscious disregard of your obligation to gather the materials and thoughtfully consider them, can be a breach can be a failure to exercise judgment in good faith. Now, why is that important? That's important because under the Delaware law and under the law of most states, boards can be exculpated for a decision that constitutes a violation of their duty of care. That means they can be absolved even when they've acted grossly negligently of any liability. They cannot be for a breach of duty of loyalty, and they cannot be if that duty of care was a breach of good faith at the same time.